Yeah, so your last remark is very important, because I will be addressing a slightly different issue compared with what you were addressing earlier. So it is not to repeat, but rather to complement. So I'm not going to discuss what it means to be a good host of these institutions, but rather if there is a sort of special responsibility, if you're expected to fulfill a sort of exemplary role in compliance with international law and also in promoting the work and support for the work of the court. So that's kind of what I want to look at. This is my question. So has the Netherlands endorsed the idea that it has this special responsibility, being the host state of the ICJ, to advocate for constructive cooperation with the ICJ and more generally for compliance both at home and abroad with obligations under international law as confirmed in rulings of the ICJ? So that's what I wanted to look at, sorry. The idea that The Hague is special, that The Hague is the legal capital of the world is, well, it was mostly in fashion in the 2000s. So here are a couple of books on that theme. I can actually reveal that Niels Blokker wrote a chapter in the one on the left about headquarters agreements, but many other such books appeared in the 2000s, confidently proclaiming The Hague as legal capital. And when I went to the Bevrijdingsfestival last week here in The Hague, again, the city of The Hague was bannered as City of Peace and Justice, as Hannah May was performing her greatest hits. And if you look at the website of the court, of the City of The Hague, again, International City of Peace and Justice. So we have not let go of that ambition. So then that made me curious. So does the position of The Hague, being this international city of peace and justice or legal capital of the world, being also host city of the ICJ, does that make exceptional demands on the Netherlands? And does the government endorse this? And then if you look at earlier statements, this is actually from the same book that Niels contributed to. There was a speech by Maxime Verhagen, then the Minister of Foreign Affairs. So he was writing this as a Minister of Foreign Affairs. And he stated, I admit that the position of The Hague as City of Justice and Peace makes exceptional demands on the Netherlands as a member of the international community. It means, for example, that the government consistently raises the issue of cooperation with the legal institutions in The Hague in its dealings with other countries. And then as an example, he mentioned he recently went to Sudan and called on Bashir, well, basically to surrender himself to the ICC. Of course, we can wonder already if Veldkamp has done the same on his last visit to Israel, if he has asked Netanyahu to surrender himself here in The Hague. And in the same book, Jan-Peter Balkenende, who was then our boss, the prime minister, he phrased it a bit more carefully. So he said, thanks to The Hague, the Netherlands holds a unique position in the dynamic world of international law. And the government supports The Hague in its ambitions and so on. And he was also referring here to Article 90 of the Dutch Constitution, which basically only says this, the government shall promote the development of the international legal order. And then if you look at the current website of the Netherlands government, one of the ways to do this, to comply with this obligation, is to be a good host country and to support the international institutions, including the ICJ, in its work. So that is clearly seen as derived from this constitutional obligation. Okay, so I was wondering today, when we have a series of, well, some people call them rather controversial cases, I was wondering if the Netherlands still endorses this special responsibility. So this is from a newspaper article on the 26th of January of 2024. So that's on the day that the International Court of Justice issued its first order on provisional measures in the case initiated by South Africa against Israel. So the newspaper is from before the ruling was issued, the morning before. So already Canadian Prime Minister Trudeau and the Belgian government had already promised or pledged that they, Canada and Belgium, would abide by any decision of the ICJ, no matter what that decision might be, because it's the ICJ. So then the Netherlands minister, Hanke Bruins-Slot at the time, was asked, would you make the same commitment? And then she said, no, I do not want to commit myself in advance to a court ruling. And then she made this remark, or at least her office, her ministry made this remark. The fact that the Netherlands is host country of a court that sits in the capital of international law is not relevant in this case, according to the ministry. So in, when was it? On the 23rd of October of 2024, so last year, the Advisory Council on International Affairs became increasingly concerned about the Netherlands' position with regard to what's happening in Gaza. And they wrote a letter to Caspar Veldkamp, a letter suggesting a new direction for the Netherlands in the Israel-Palestinian conflict. And one of the suggestions was to advocate both at home and abroad for compliance with obligations under international law that arise from the relevant rulings of the ICJ, both advisory opinions and contentious rulings, and recognize that complying with and protecting international law is of geopolitical importance, and those two, and now I read from the slide, endorse the idea that the Netherlands has a special position in terms of compliance with international law, given inter alia its role as the host country of the ICJ. And so this I wanted to look at sort of seriously and from an academic perspective. So very quickly after this report was issued, there was a lot of support in the popular media for this call for an endorsement. And so here you see it in the newspapers. And even in a recent meeting that a group of international NGOs had with Minister Schoof and Veldkamp, those NGOs made reference to this special responsibility. So the 8 organizations, that's Amnesty and Oxfam, they believe that the Netherlands, as host country of the ICJ, has an exemplary function, but unfortunately does not live up to it. And then the chair of Doctors Without Borders is quoted as saying, the Netherlands calls itself a champion of international law, but is not showing this sufficiently. But certainly in the last couple of days, the Netherlands government seems to have shifted its position slightly. And in a letter that Veldkamp wrote to Kaja Kallas, the EU High Representative for Foreign Affairs, he explains the sudden change of position inter alia by referring to the provisional measures orders of the ICJ, which is quite remarkable because those are already of more than a year old. So now I wanted to look at the second part of my question. Yeah, I'm about halfway in time also. So I want to look at how does the Netherlands behave in front of the International Court of Justice? So does the Netherlands adopt a constructive approach when appearing or when litigating before the International Court of Justice? So when initiating contentious proceedings, when intervening in proceedings already initiated by others, or when taking part in advisory proceedings. So I had a look at the Netherlands appearing before the court. And of course, I am mostly interested not in the bilateral disputes. There's been a dispute between Netherlands and Sweden, basically a diplomatic protection type dispute. That's not interesting for present purposes. I was more interested in the Netherlands acting not to defend its own particular interest, but the general interest. So does the Netherlands engage in what we often call strategic litigation? That is seeking to use the authority of the ICJ and of international law to advocate for social change on behalf of principles, so in defense of principles, but also it could be on behalf of individuals or groups whose voices are otherwise not heard. And so I was wondering, is the Netherlands doing this sort of thing? So I had a look at the history of the Netherlands at ICJ. And I have to begin by noting that it's actually quite rare for states at the ICJ to initiate cases in the general interest, or to intervene in other cases in the general interest. If you look at past interventions and initiations of contentious proceedings, almost always there's a particular interest involved. So it's only a recent trend that states start to litigate on behalf of the international community as a whole. So these are, well, in my view, the only examples. Of course, you can debate a few. So most of them are of rather recent date. And as you can see, the Netherlands is quite active in these common interest litigations. So far, the Netherlands has only once itself initiated such a case. So that's not a lot, just once. That's a case initiated together with Canada against Syria, accusing the latter, Syria, of torture as part of its violent repression of civilian demonstrations starting in 2011 and continuing as the situation in Syria devolved into an armed conflict. Of course, this is an interesting case now with the change of regime, the fall of the Assad regime. I wonder where this case is going. I checked, and the Netherlands is not prepared to withdraw these or remove it, have it removed from the docket. So the case is still pending. But yeah, we don't really know how the current Syrian regime, how they will respond to these allegations. But clearly, the Netherlands has no interest in this case. So the Netherlands is initiating these proceedings as a state party to the Torture Convention. So erga omnes partes. But there are many, many other such parties. The convention has 175 states parties, so the Netherlands is just one of them. All the others decided not to do this. And the Netherlands is also considering to initiate contentious proceedings against Afghanistan, again, for breaches of the obligations that are not owed to the Netherlands. So obligations under the Convention on the Elimination of All Forms of Discrimination Against Women. And the Netherlands then purports to act in the general interest or as a state party to this convention, and also in the interest of the Afghan women and girls in particular. But it's not on the slide because officially these proceedings have not been initiated. Yes, you first have to exhaust negotiation. Yeah, and then interventions. That is also a very recent trend. So you can intervene as a state in cases that have already been initiated by another state. And basically there are 3 such cases. They are all pending still. So there's a case initiated by the Gambia against Myanmar about genocide allegedly committed against the Rohingya minority in Rakhine State in Myanmar. So the Gambia itself is acting in a general interest, but so are most states intervening, including the Netherlands. Secondly, there is a request by the Netherlands to intervene in the case initiated by Ukraine against Russia. You don't see this on the slide because clearly Ukraine has a special interest in these proceedings, so it's not acting in the general interest. But the Netherlands intervention is, well, you could say it's in support of Ukraine, but you could also say it's in the general interest. But interestingly, the Netherlands has not requested to intervene in the third and last such case, the case initiated by South Africa against Israel, relating to genocide in the Gaza Strip. And this is remarkable because a lot of other states have done so, including Spain and Ireland and other countries. So you do see, at least I see, some inconsistency here. Then I wanted to look also at advisory proceedings. Interestingly, the Netherlands participates in almost all recent advisory proceedings, starting in the late 90s. And in only 2 cases has the Netherlands suggested to the court not to render an advisory opinion. That was in the legality of the threat or use of nuclear weapons proceedings. These were basically about the lawfulness of the nuclear deterrence policy that was very much on vogue in times of Cold War, but even today, I guess it's still being used. So the Netherlands did not find it helpful to have a an opinion on the lawfulness of nuclear deterrence. And the other case is the request about the wall, the legal consequences of the construction of a wall in the occupied Palestinian territories. So here too, only second time in history of the Netherlands suggested that maybe an advisory opinion was not welcome. So urged the court not to issue an opinion. Well, thankfully, the court did not listen to the Netherlands at the time and issued the opinion. So let's now look at more recent examples. So there is the advisory proceedings on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, an advisory opinion issued last year. So the Netherlands did participate. It did not provide a written statement, but only an oral statement. But surprisingly, in this oral statement, the Netherlands did not mention either Palestine or Israel, not even once. It was a very strange pleadings to hear. Basically, what René Lefeber did was give the ICJ a lecture on the right to self-determination, explaining to the ICJ its own rulings, as if they had no idea what they had just written before. If I were a judge at the ICJ, I would have been deeply offended by it. So this is oral pleadings that were delivered by René Lefeber. You see him here on the slide. He's the legal advisor and head of the International Law Division at the Ministry for Foreign Affairs. And he represents the Netherlands before the court. And in spring of, last year? Yeah, he announced a lecture that he was going to deliver to the Royal Netherlands Society of International Law, exactly on the topic I'm speaking on now, using international litigation to promote international law, the Dutch experience. But before he came to the Royal Netherlands Society to deliver this address, he was asked a few critical questions, including from myself, and then he decided to withdraw as a speaker. So he never gave this lecture. Very interesting. So I'm also, to be honest, I'm more and more dissatisfied with the way that the Netherlands government is dealing with the situation in Gaza, refusing to speak out, refusing to support the ICJ when it deals with these matters. So many people are increasingly dissatisfied by the lack of Dutch support for the ICJ when it comes to Palestine, which is in clear contrast with the Dutch experience that René Lefeber wanted to speak on. So every week for over 70 consecutive weeks now, I think, former ministers, diplomats and civil servants, they stand outside the main entrance of the Ministry of Foreign Affairs, very close to nearby, in protest. And academics like myself join them. So they, or we, if you like, are not asking for the minister's social media outrage, as he's sometimes suggesting. We just want the Netherlands to be more supportive of the ICJ, special rapporteurs, basically everybody who is speaking out against what is happening there in Gaza at the moment. But the minister and his immediate staff, including René Lefeber, they refuse even to speak with these weigerambtenaren, as they are now called, on reasonable terms. And thus, others are making more realistic assessments. So they understand far more clearly than our government, it seems now, the geopolitical reality there. So they read the words and the intentions and the actions of the Israeli leaders and take them at face value. They know the Western world, including Netherlands, will not meaningfully intervene. And this is not even likely to change after the sudden change of mind by Veldkamp of last week. So I only have 1 more minute. So that raises the issue of double standards. And I'm not the only one that is concerned about double standards in the way the Netherlands associates itself with the work of the ICJ and with international law more in general. So what are double standards? Well, double standards may be understood as a inconsistent, apparently inconsistent treatment of similarly situated actors, actions, or circumstances, where such treatment lacks a principled basis and undermines a commitment to equality, impartiality, consistency, and universality. This is a quote from a recent report issued by Harvard Law School. But okay, we all know intuitively what double standards mean. And in the IVA report, the Advisory Council of International Affairs report that I referred to earlier, they also note a clear double standard here. The active engagement in some cases before the ICJ contrasts with the Netherlands' stance in other currently pending proceedings, and notably its more reserved approach to the case brought by South Africa against Israel, but also these advisory proceedings that I referred to earlier. So in its advisory letter that I already quoted from earlier, the AIV cautioned against the risks of perceived double standards in applying international law, noting how inconsistencies, which are often motivated by political rather than legal considerations, can undermine both the credibility of the Netherlands as a champion of international law, but also the broader international legal system, including the ICJ itself. Yeah, I wanted to read the quote, but I don't think that's necessary. They're just making the same argument, more or less, that Niels Blokker actually referred to it. So we desperately want this accountability mechanism for Ukraine, but of course we have no interest whatsoever in even thinking of a similar accountability mechanism with regard to what's going on in Palestine. And that is the argument that the IVA was trying to make, or making actually, in this quotation. So thank you for your attention. And I think it was sort of within a lot of time. No?
Thank you.